to report to it. These are the officers that should determine the issue of wasteful spending. The fourth respondent submitted that the advice by the fourth respondent on remuneration and benefits for the CAS was issued within their constitutional mandate under Article 230, Subarticle 4B of the Constitution and Section 11 of the SRC Act, and not the SRC Regulations 2013. The advice was thus based on an objective and fair process which took into account the principles outlined in Article 230, Subarticle 5 of the Constitution, and the job descriptions by the fifth respondent. The first interested party submitted that under Article 228, 4 and 5 of the Constitution, it was not responsible for paying remuneration and benefits to the CASs or any other state or public officers following their mandates under Article 228 of the Constitution. We also note that the initial CAS office, as established in 2018, was graded under Job Group U, and the appointed persons were to enter at the midpoint of the salary scale. After this office was abolished and a new one established on 11th of October 2022, the position was graded under Job Group CSG3 in the public service. The gross salary is above 700,000 shillings plus other emoluments as seen from the letter from the fourth respondent. The second respondent, with reference to the 27 additional CSS, made known that their financial provision was given the green light by the National Treasury, which indicated that there was sufficient funds to cater for the additional numbers. We referred to Article 230, Subarticle 4 of the Constitution, which provides for the powers and functions of the SRC. Further to the above, Rima J in the Okia case found that failure to involve the fourth respondent on the financial matters of the CS office was a serious omission, rendering the establishment of the said office unconstitutional. It is therefore clear to us that the fifth respondent should have consulted the SRC in order for it to ascertain the resultant financial implications. A related issue arising within the context of the various financial implications is the question of whether this court can make a decision on budgetary issues. The court in the case of Wanjiru, Gikonyo and two others, expounding on this issue, opined as follows. By justiciability, it is meant a matter proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision. A court must satisfy itself that the case before it is not caught up by the bar on non-justiciability. The concept is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. It is our considered view that based on the separation of powers doctrine, budgetary concerns fall within the realm of policy and rightly belong to the other relevant arms of government as may be appropriate. We thus decline the invitation to delve any deeper into that arena.
I'll now ask my honourable brother, Justice Alem Fisram, to deal with the next issue.
The next issue is, was the President improperly enjoined as a party to the proceedings? The second to the fifth respondent submitted that the first respondent was improperly enjoined to the present consolidated petition. The petitioners on their part did not oppose the said prayer, but contended that the misjoinder was not fatal to the consolidated petition. Having considered the submissions of the parties on this issue as set out above, we are guided by Article 143 of the Constitution and the decision of the Supreme Court in, and I will not read the full citation, but more commonly known as the BBI case, where at the following paragraphs the court stated as follows, and here I will only quote the relevant paragraphs because we have quite a long quote. Anybody or any party aggrieved by the President's actions or failures, can initiate proceedings against the Attorney General, who by virtue of being the legal representative of the government in legal proceedings also represents the President, who is the head of government. The immunity, on the other hand, offers protection that shields the President from civil suits being filed against them in their personal capacity. I will further quote, "As such, pursuant to Article 156(4) of the Constitution, the exercise of public power by the President can be challenged in a court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein the court may issue appropriate reliefs." This leads me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143(2) of the Constitution by holding that civil proceedings can be instituted against the President or a person performing the functions of the office of President during their tenure of office in respect of anything done or not done contrary to the Constitution. Pursuant to Article 143 of the Constitution and based on the law as set out above, we find that the first respondent was improperly enjoined to the consolidated petition. We further find that the misjoinder is not fatal to the consolidated petition, but take the opportunity to urge the petitioners and future litigants to avoid this practice in light of the unequivocal pronouncements by the Supreme Court on this issue.
Thank you. I'll now ask the Honorable Lady Justice Hedwig Angudi to deal with the next issue.
The next issue is whether the consolidated petition was drawn with sufficient precision. In a constitutional suit, a party that alleges violation of his or her rights must plead with reasonable precision the manner in which the rights have been violated. We have a number of authorities on this. And our interpretation of the above provision is that for a constitutional petition to be sustainable, it must satisfy the threshold set out in the authorities we have cited. It therefore follows that the mere citing of constitutional provisions is not enough. The petitioners must, with some reasonable degree of precision, identify the constitutional provisions that are alleged to have been violated and the manner in which the said provisions have been violated from the facts and the evidence of the case. In the circumstances of this case and material placed before this court, we find that the above threshold has been met by the petitioners. And the next issue is on unpleaded issues raised in submissions and supplementary affidavits. The second and fifth respondents and some interested parties opposed the introduction of new issues and new prayers as raised by the third petitioner in its supplementary affidavit dated 5th of May 2023 and the second petitioner's further affidavit dated 2nd of May 2023. The second respondent submitted that new issues were also added in the submissions of the second and third petitioners in paragraphs 39, 54, 56, and 56. The fifth respondent challenged paragraphs 14 to 20, 29 to 31, and 43 to 50 of the third petitioner's supplementary affidavit, and paragraphs 29 and 33 of the second petitioner's further affidavit. The 2nd to 7th, 9th to 18th, 20th, 21st, 23rd to 30th, and 33rd to 51st interested parties also challenged the admissibility of evidence in paragraphs 13 to 17 and 33 of the second petitioner's further affidavit, and paragraphs 18 to 33 and 36 in the supplementary affidavit of the third petitioner. The 19th interested party also challenged the admissibility of the evidence in paragraphs 14 to 20, 29 to 31, 33, 43 to 50, 59 to 61 of the third petitioner's supplementary affidavit. Counsel emphasized that the record should reflect that they had no opportunity to reply to the new allegations and had not admitted to the contents of the impugned paragraphs. We have referred to the Supreme Court case in Raila Amolo Odinga and Stephen Kalonzo versus IEBC and others, and also the Court of Appeal case in IEBC and another versus Stephen Mutinda Mule and 3 others. We are satisfied that the second and third petitioners tried to introduce new issues that were neither pleaded in the original petitions but were found in their further affidavit, supplementary affidavit submissions, and also found in the amended petition filed out of time, which the court declined to admit. Evidently, each party is at liberty to frame his case in his own way while paying regard to the rules of pleadings, and in the end is ultimately bound by the manner in which the pleadings were drafted. As such, a party cannot be allowed to raise a different or a fresh case without an amendment to the pleading. The court record reflects that the third petitioner's request to extend the time within which to file and serve the amended petition was declined. Taking this into consideration, we have confined our decision to only the matters properly pleaded before this court and as captured in the issues we framed above.
Thank you, Lady Justice Ongudi. At this point, what we have been reading are contents of the majority opinion. At this point, I'll ask the Honorable Lady Justice Hedu Gangudi to read her judgment.
So I have considered in detail the majority decision in this consolidated petition, the factual background, the summary of the submissions advanced by the parties, as well as the issues for consideration and determination as framed. I'm in agreement with most of the issues in the majority judgment. These issues are the jurisdiction of this court, res judicata, public participation, enjoyment of the President and the control of budgets, and lastly, the financial budgetary estimates. I, however, differ with the majority on 2 issues. Namely, 1, whether the office of CAS was constitutionally established, and 2, whether the 50 CSs were appointed in accordance with the law. The office of the CAS was first established in Kenya on 24th of January 2018 by the former President Uhuru Kenyatta. He subsequently nominated and appointed the CSs alongside the cabinet secretaries and the permanent secretaries. This decision was soon after challenged in the Okiya Omtata case. And on 20th of April 2021, Justice Murima rendered his judgment in which he declared the establishment of the CS office unconstitutional. The orders issued are found at paragraph 309 of the said judgment. A perusal of the 5th respondent's CEO Simon Rotich's response in the ELRC petition number E174 as relied upon by the first respondent in the instant consolidated petition indicates that a while later, on 19th of September 2022, the PSC received a letter from the then head of public service, Mr. Kinyua, informing it of the President's proposal on the establishment of the office of the CS in the public service. In brief, the letter set out the history of the office and the justification for its establishment. Equally, the President proposed that the office of the CAS be ranked in the public service within job group CSG3. Further, that one position be established in each ministry, except in the Ministry of Interior and Coordination of National Government, that would have 2 positions in light of the scope and significance of its portfolio mandate. The letter as well listed the job description of the CAS and relevant qualifications. Based on this, the 5th respondent at its weekly meeting on 21st of September 2022 discussed the proposal and observed that the office had been established in January 2018. However, the process of establishing it had been declared unconstitutional in the Okiya Omtata case for lack of compliance with provisions of the Constitution. Considering the court's decision in the said case, the fifth respondent resolved to abolish the CAS office established on 24th of January 2018, comply with the orders of the judgment in light of the President's request, and conduct public participation. The fifth respondent, via a press advert on its website and the local dailies dated 21st of September 2022, invited members of the public to submit their views on the proposed establishment of the said office. And following the call for the public to issue its views on creation of the office, the second petitioner filed the ELRC petition number E174 of 2022 against the fifth respondent for the reason that the advert was illegal for violation of Section 27(1) of the PSC Act insofar as it failed to include fundamental details to enable the public make meaningful and informed contributions towards the establishment of the office. Further, that the advert was unconstitutional for violating Article 201(d) of the Constitution as it seeks to establish an office in the public service with duplicity of roles as that of the Principal Secretary. Justice Mbaru, in the said matter, satisfied that the fifth respondent had complied with the orders issued in the Okiya Omtata case and the dictates of the Constitution held as follows in the judgment dated 16th of February, while dismissing the petition. Upon being satisfied that the creation of the office of CAS is justified, upon being satisfied that the financial implications of creating such office is indicated, and that the office so created relates to or supports the core functions of the public body requesting for its creation, such satisfaction is sufficient for the first respondent. It is its core function under Section 27(1) of the PSC Act, and in this regard, the internal processes for levels for grading, designation, qualifications and remuneration cannot be faulted. The fifth respondent, in its response dated 11th of October 2022 to the President's proposal, informed of the outcome of the public participation exercise, steps taken to comply with Section 27 of the PSC Act, and after making all these considerations, recommended establishment of the office as proposed. Following this conclusion, the office of the CAS was established via a letter dated 11th of October as communicated by Joseph Kinywa, the then head of public service, to the fifth respondent's chairperson, Mr. Mushiri. With this contextual background in mind, it's my considered view that the petitioners in both petitions, that is the Okiya Omtata case and petition number E174 at the ELRC court, were concerned about the legality of the actions of the former and current presidents in establishment of the office of the CAS in light of the dictates of the Constitution. The High Court, as discussed, found that the claim that the processes towards the establishment of the said office was in contravention of the Constitution, as well as Sections 27 and 30 of the Public Service Commission Act, which succeeded. The court as such declared the office of the CAS unconstitutional. That is at paragraph 310B of the judgment. This decision in the end formed the basis of abolition of this office and establishment of the new office whose creation process was affirmed by the ELRC. Appreciating all these factors, this court will now make a determination on this issue as presented by the petitioners and defended by the respondents and interested parties. It is worthy to note and emphasize that the decision in the Okiya Omtata case, as pronounced by Justice Murima, was stayed by the Court of Appeal. The outcome of the same is a matter that remains unresolved and will inevitably affect the outcome with reference to the office of the CAS in general. On the other hand, the decision in the ELRC petition E174, as determined by Justice Mbaru, was the basis of the fifth respondent's decision to either complete the process of establishing the new office of the CAS or end the same altogether. I say so because from the chronological timelines, it's clear that the fifth respondent did not call for interviews for the CAS position until the ELRC delivered its judgment on the 16th of February 2023. It is further noted that this judgment has not to date been appealed against. Manifestly, the contents of the two decisions arise from courts of concurrent jurisdiction, which legally do not bind this court, as we are of courts of equal status. This was underscored by the Court of Appeal in the case of Bellevue Development Company versus Francis Gikonyo. Be that as it may, this court cannot turn a blind eye to the first and fifth respondents' actions. It is clear that the first and fifth respondents herein, owing to the adduced correspondence before this court, in an attempt to comply with the law and the pronouncement of the High Court, established a new office of the CAS based on the orders issued. This compliance was given the green light by the ELRC in its judgment by Justice Mbaru, which cannot be ignored. This act was in line with PSC's mandate under Article 234, 2A, Roman 1 of the Constitution, which makes known that one of its powers and functions is as follows. The Commission shall, subject to this Constitution and legislation, establish and abolish offices in the public service. My opinion on the preceding point is informed by the Supreme Court observation in the case of Attorney General and two others versus D and 17 others. I've cited the portion there. Evidently, the regularization of the office of the CAS as proposed by the President in the letter dated 19th of September 2022 and recommended by the fifth respondent in the letter dated 11th October 2022, being premised on the rule of law, cannot be faulted. The unavoidable conclusion I come to is that the process undertaken to establish the new office of the CS that endorsed 23 posts as seen from the correspondence was lawful. For that reason, the ensuing determination will only speak to the constitutionality of the additional 27 CAS posts. The office of the CAS, as submitted by the parties, was constituted under Article 132 of the Constitution, which essentially spells out the functions of the President. An answer to this question involves interpretation of this sub-article by applying the pertinent principles of constitutional interpretation, which have been dealt with in the majority judgment. But I have referred to the Supreme Court case of Evans, Odhiambo Kidero and four others versus Ferdinand Waititu, and the case of Communications Commission of Kenya and five others versus Royal Media Services Limited. And guided by the law and opine above, I find one of the facets of a holistic interpretation to be an interrogation of the past. Fundamentally, the question is what informed the description of the functions of the President before the promulgation of the Constitution 2010. I've referred to the final report of the Constitution of Kenya Review Commission, which states that on the attributes of the President, they envisioned and noted the citizens' contributions. with respect to the office of the President, that one, the President should not be above the law. A majority asserted their concerns were that it should be possible to prosecute him or her for offences while in the office. In this regard, it was also suggested that the Constitution provide for the President's removal for misconduct. Two, the powers of the President should be curtailed. Kenyans felt that the President should not have the exclusive power to appoint senior government officers. It was suggested that for many of the appointments be vetted by Parliament, and that the President should not have the power to determine the election dates. Now, the Commission on this point concluded as follows at page 199. The Presidency, the head of state, must be more than ceremonial. He or she should have reasonable powers. However, those powers should be limited. Excess powers upset the internal balance within the executive, and the principal function of the Presidency would be to symbolize national unity and promote national integration, security of state, and protection of the Constitution. So it's clear from the historical point of view that Kenyans were keen that the President should have limited reasonable power that is exercised within the confines of the law. And turning to the attributes of the fifth respondent, which was categorized under the organs of the government, the committee at paragraph 13.65 under chapter 13 revealed as follows. It is clear that what the people were asking for was the re-establishment of principles of public service, neutrality, impartiality, and independence. The people of Kenya want to see appointment processes that are transparent and offices that are not only accountable to the people but also capable of guarding public wealth and resources. So out of this conclusion, one of the first recommendations made by the committee was for the establishment of an independent public service commission. Article 132(4)(a) of the Constitution provides that the President can create an office in the public service in accordance with the recommendation of the fifth respondent. To my mind, the intention of this sub-article was to limit the President's power to create an office in the public service to the extent that the creation must be done in tandem with the fifth respondent's recommendation. The recommendation must basically be guided by the edicts of the Constitution and the law. It is apparent, therefore, that the two conditions as conceived were intended to be inseparable and work in harmony. This, in my view, was the intention of the drafters of the Constitution and the aspirations of the Kenyans. With this background in mind and principles of the constitutional interpretation, the question that crystallizes is whether the additional 27 posts in the office of the CAS were properly constituted in light of the Constitution and the law. To answer this question, I will first examine how a public office under this article is established. And with reference to Article 132(4)(a) of the Constitution, the Public Service Act under Section 30 provides as follows. Recommendation to the President. 1. Where the President under Article 132(4)(a) of the Constitution requests the Commission to recommend the establishment of an office in the public service, the Commission shall act in accordance with the conditions provided for in this part. And then the conditions of establishment of an office in the public service is clearly provided for under Section 27 of the PSC Act. Fundamentally, for an office established under Article 132(4)(a) of the Constitution to be properly constituted, the same must satisfy the threshold set out under Section 27 of the Public Service Commission Act, as read with the provisions of Articles 10 and 232 of the Constitution. The number of persons that can be recommended for this position is not expressly stated in the Constitution or the PSC Act. Similarly, the requirement for approval of the National Assembly for the CS's position is not provided for. What is clear is that any post that is established must comply with the principles of the Constitution and Section 27, as read with Section 30 of the PSC Act. A look at the material before this court reveals that through the affidavit of Felix Koskei, the head of public service, dated 24th of April 2023, that on 23rd of February, the President wrote to the respondent seeking a review of the complement of CAS within the public service to vary from one in each ministry to one in each state department. On the same day, the fifth respondent CEO, Mr. Rotich, wrote to the PS, Chris Kipto, seeking concurrence on the availability of funds to meet resultant expenditure on the additional posts of 27. The fifth respondent, in response to the President's letter, consented to this variation in its letter dated 27th of February. In the letter, the fifth respondent noted that the consent was based on workload attendant to the role of the CS and National Treasury's confirmation of funds. Following this communication, the President increased the complement of the office with an additional posts and asked the fifth respondent to recommend persons to be appointed, which it did. Additionally, in response to a letter dated 18th October and two letters dated 10th March 2023 by the fifth respondent, SRC wrote a letter dated 14th March to the fifth respondent advising it on the job valuation, grading and remuneration and benefit structure for the said position. Soon after, the second to 51st interested parties were nominated on 16th of March and appointed by the President on 23rd of March. From the letter dated 23rd of February 2023, it's discernible that the nature of the office of CS varied drastically. In the initial letter dated 19th of September 2022, the proposal was for one position in each ministry, except in the Ministry of Interior and Coordination. While in the letter dated 23rd of February, the proposal was a review of the complement of CS within the public service to vary from one in each ministry to one in every state department. This letter introduced a new element in the office that was not accounted for in the previous process that was found to be lawful. Furthermore, despite this vital additional aspect, the fifth respondent went ahead to make a recommendation without seeking further information and justification as required under Section 27 of the Public Service Commission Act. Likewise, the sequence and procedure that led to the establishment of the 27 additional CS posts did not involve adherence to the constitutional principle under Articles 10 and 232 of the Constitution. I therefore find that the manner of establishment of the additional 27 posts in view of Article 132, 4A of the Constitution, Sections 27 and 30 of the Public Service Commission Act, and the necessity of the fifth respondent's recommendation was unconstitutional. On the flip side, I find the establishment of the CAS office in the public service with 23 posts to be constitutional. The orders will be as proposed in the majority judgment.
Thank you very much, Lady Justice Hedy Vungudi. I'll now ask my learned brother, the Honorable Justice Alim Fisram, to deal with two of the remaining issues before we pronounce the final orders.
The next issue is what is the constitutionality of Section 26(2) of the SRC Act and the SRC Remuneration and Benefits of State and Public Officers Regulations 2013. Having considered the submissions of the parties as set out above, we take note that the central arguments made by the petitioners in relation to the above issue are as follows. First, that the fourth respondent refused to discharge its constitutional duties and defend its independence on behalf of the people of Kenya. from the unconstitutional encroachment and interference by the National Assembly as evidenced by the enactment of Section 26(2) of the SRC Act. Second, that the fourth respondent failed to undertake compulsory public participation in the process that resulted in the enactment of the SRC Remuneration and Benefits of State and Public Officers Regulations 2013. In response to the above, the fourth respondent submitted that it undertook extensive public participation relating to the impugned provisions, and that the same is evidenced in its annexure collectively marked as ARG3 in the replying affidavit of Ms. Anne Gitau. However, and more importantly, it submitted that while the provisions of Order 3, Rule 5 of the Civil Procedure Rules and the Constitution of Kenya, Protection of Fundamental Rights and Freedoms, Practice and Procedural Rules 2013, do permit the joinder of causes of action, the issue of the creation of the position of CAS and the subsequent appointment of the second to 51st interested parties as CASs, and the issue of the constitutional validity of Section 26(2) of the said Act relating to the advice and remuneration and benefits of the CASs are independent and distinct causes of action. Further to the above, the issues do not arise out of the same act or transaction or series of acts or transactions, and no common questions of law or fact would arise should these two issues be considered together. The two causes of action joined in the petition are fundamentally disparate in nature, both legally and factually. Each cause of action carries distinct elements, legal standards and remedies necessitating separate and individual consideration. The fourth respondent contended, and we agree, that by joining these unrelated causes of action, this court may not be able to render a fair and efficient resolution of that particular issue, given that it derogates from the core issues before this court. This court is of the view that in order to ensure efficient administration of justice, each cause of action ought to be litigated independently to ensure the proper application of law, presentation of evidence, and resolution of disputes. In the present matter, this court has not had the sufficient opportunity to carry out the above exercise in relation to that specific issue. Accordingly, and based on the reasons set out above, we decline to entertain this issue and find that the same is an unrelated cause of action within the context of the consolidated petition. The petitioner is, however, at liberty to raise the issue as a separate cause of action should it wish to pursue the same. The next issue is whether the Controller of Budget was improperly enjoined as a party to the consolidated petition. Having considered the submissions of the parties as set out above, we note that the crux of the first petitioner's case with respect to the first interested party is as follows. A. That the first interested party oversees the implementation of the budget of the national and county governments by authorizing withdrawals from public funds under Articles 204, 206, and 207 of the Constitution. B. That the first interested party is prohibited from approving any withdrawal from a public fund unless satisfied that the withdrawal is in accordance with the law. C. That the first interested party would be required to approve any withdrawal of public funds to pay remuneration and benefits of persons appointed in the office of CAS for which there is currently no lawful authority. Based on the above, the petitioners enjoin the first interested party, presumably because they were concerned that it may make payments of remuneration and benefits to the CASs which are not authorized by law. In responding to the above concerns and regarding the assertions made by the petitioners, the first interested party clarified that its responsibilities do not involve paying remuneration and benefits to the CASs or any other state or public officers. The mandate of the Controller of Budget under Article 2284 and 5 of the Constitution is to grant approval of withdrawal of funds in accordance with the law and not to effect payments on specific transactions. It is the responsibility of the relevant accounting officers to pay remuneration and benefits to the respective members of staff. The fourth respondent accordingly submitted, and we agree, that it ought not to have been enjoined in the present proceedings. We have looked at the consolidated petition, and we find that no cause of action has been disclosed against the first interested party. Further, the petitioners have not sought any specific orders against the first interested party, nor have they set out in detail any specific violations of the law demonstrated by the first interested party?
Thank you very much, Judge Alim Fisram. Before we conclude our judgment, we are constrained to comment about the conduct of counsel for the third petitioner, Mr. Oshiel Dudley. On 19th of June 2023, he authored a letter addressed to the Deputy Registrar titled Professional Duty to Disclose, requesting the Deputy Registrar to bring to our attention a recent decision of the Supreme Court whose findings would aid us to deal with the present consolidated petition. At the time of the letter, the proceedings had been closed and a date for judgment set. We thus found the conduct of Mr. Oshiel inappropriate. For obvious reasons, we did not refer to the decision he referred to, and it was not necessary to do so. These are our final orders. Having answered all the issues that we framed in the consolidated petition, we now make the following final orders. A, that the current Office of Chief Administrative Secretary, created by the first and fifth respondents and contained in the Kenya Gazette Special Issue number 12432, dated 12th of October 2022, and which announced the vacancies thereof, is unconstitutional. B, that whereas there was some reasonable public participation on the first complement of 23 Chief Administrative Secretaries, there was no such participation regarding the additional complement of 27 office holders. C, that the entire complement of 50 Chief Administrative Secretaries, which is to say all the second to the 51st interested parties, is unconstitutional. D, for the avoidance of doubt, the notification by the first respondent dated the 16th of March 2023, appointing the second to 51st interested parties to the office of Chief Administrative Secretary is hereby quashed. E, that the prayer that Section 26, subsection 2, Section 2 of the Salaries and Remuneration Commission Act and the Salaries and Remuneration Commission, Remuneration and Benefits of State and Public Officers, Regulations 2013, be declared unconstitutional is disallowed. F, a declaration is hereby issued that the first respondent enjoys constitutional immunity from suit and was illegally joined into the proceedings. G, that the petition against the first interested party, controller of budget, is hereby dismissed. The last issue relates to costs. Costs ordinarily follow the event and are at the discretion of the court. We find that the consolidated petition raised constitutional issues in the public interest. The order that commends itself to us is that each party shall bear its own costs. Thank you. Thank you, Dr. Kamodo. If you can give us just 1 minute to sign our judgment.
Shall I ask Mr. Deputy President to plead my case for
All right. Now, Dr. Kamodo.
Yes, my Lord, we are enormously grateful for the well-reasoned decisions that the court has rendered.
Yes.
We will be requesting for copies of the judgment at the earliest stage, as well as the proceedings. Further to that, we will be making an application for the stay of the decision of the majority to enable us seek a second view at the appellate court